Buenos días de nuevo todo el mundo. En esta ocasión sí que alguien de la Universidad de Deusto recibe y da la bienvenida a todo el mundo, los que están presencialmente, físicamente aquí y a quienes tenemos pues a través de internet conectados y a nuestros ponentes. Bueno, yo doy la bienvenida, soy profesora de Derecho Mercantil de la Universidad de Deusto, aunque no me crié, por decirlo de alguna manera, académicamente aquí, ni siquiera comencé mi carrera académica aquí, pero bueno, sí que puedo decir que fui acogida, muy buena acogida aquí, entonces confío en que esa sensación de acogimiento también la disfruten todos ustedes. So, let's start in English now. In this panel, the topic is stand-alone actions. So private enforcement, absolutely. But we are going to focus on the experience in different countries. United Kingdom with Ben Lasserson, with whom we are trying to contact. Helmut Brockelmann, you have here on my left, and Miguel Sousa Ferro. So we have United Kingdom, we have Spain, we have Portugal, different legislations and different experiences that these three professionals of law in the law boutiques and lawyers, and as well from an academic. Miguel is an real academic professional, but I think that Helmut has also worked at the University of Munich as well. So you have also this academic view, I guess. And I think that we are going to start with Miguel then, I guess. Okay, yeah, no? Because Ben, Ben was the first one, but Ben is not here. So.
You want to start, Helmut? I can start, of course.
So, okay, so Helmut.
I'm always willing.
Just, you have something.
And, do we have to switch this on or how?
Here you are.
I am, yeah? Can you hear me? Yeah, thank you. Yeah, thanks for the invitation to the Universities of Deusto and Valladolid, and nice to be here today. We are going to talk about, and we are really going to talk about private enforcement or public enforcement, and in Article 102 cases, so in cases of abuse of a dominant position. The micro closer to my mouth, thanks. Okay. And is my PowerPoint presentation here somewhere, please? And well, the first slide is on some pending cases, which I would like to go through very briefly so that we just get a notion of what is going on in Europe in terms of enforcement, because I think right now most of the enforcement is public still, and certainly in the technology sector. And as I will conclude in my presentation, I think this has good reasons, and also private enforcement has a specific function in Europe, which is different to the function it has in the US. And I think it is important to be aware of these differences in order to know what is private application in Europe and what is private application in the US, which is very different, yeah? And what is the role of public enforcement. So the cases which have been there has been made reference to already in the first presentations are the Google cases, where the Commission has already adopted 3 decisions in the last years. The first one has already been, thank you very much. And now? Okay. And Irache, what do we do with Irache? Erdogan. So in the Google cases, the Commission has already adopted 3 decisions. and one has been confirmed by the General Court and is under appeal already. The others are still pending before the General Court. We also have the Facebook case, the Spotify complaint against Apple. We have cases in the UK, and we have cases in the US, which I wouldn't call private enforcement, because if the plaintiff is the FTC or the Department of Justice, this is the public enforcement within the American system, which is that you have to go to court. So this is a different thing. This is not what I would call private enforcement. So what are the cases? Google Shopping, I think, is a good example of the complexity of these cases. This is about whether self-preferencing is abusive. You have to define the market in a context where there are no prices. So the question is, how do you define markets if there is no compensation in monetary terms? So these are very difficult issues, and I think very difficult issues to be addressed by a civil court in a standalone action, which is a bit the question which I would like to raise also with the audience, with the discussion, whether these are cases which are suitable for a standalone private enforcement, or whether these are really cases which should be, at least at the current stage of development and application of Article 102, be addressed rather by the competition authorities. Complex legal issues. Another case is the Amazon case, the dual role of a, what? Me? Yes. Oh, the camera is there. So, okay. Sorry. Yeah, good.
So you have to change your, yeah.
I switch this one here off. Yeah. Good. So, okay. Yeah. Another case is the case by the French Autorité de la Concurrence, which fined Google for an exploitative abuse. So these are examples of still a bit rare, but increasing enforcement by national competition authorities. This was an abuse in the search advertising market, where the rules implemented also vis-a-vis press editors were not transparent and discriminatory, and an interim measure was applied by the authorité, and then also a fine of 150 million. We have also cases by the Italian competition authority for discriminatory use of data, and certainly we also have the famous Facebook case by the Bundeskartellamt, which has gone up and down the courts. It went to the German Supreme Court already. The interim measures which were adopted, which were first quashed by the OLG Düsseldorf, but then confirmed by the German Supreme Court. And now the main proceedings are pending, and the OLG Düsseldorf, since they don't trust their own Supreme Court, so they have made a preliminary reference to the Court of Justice to make the questions they want to ask, and avoid that the Supreme Court, the German Supreme Court, the BGH, answers these questions by themselves. So we'll see what comes out from there. The preliminary reference, you can see already the complexity. It's really 2 pages in the official journal, and very complex issues on data protection and the interface of data protection with the concept of abuse in Article 102. This is this general question, which is also, I think, yet undecided, whether regulatory infringements can add up to an abusive conduct within the meaning of Article 102. Is this really the function of Article 102, to enforce only vis-a-vis dominant companies regulatory obligations, be it data protection or also in other fields? I mean, we have seen that also in electricity cases in Spain in particular. And so, again, questions which I think must be addressed from a competition policy perspective, and must be first decided by a competition authority, preferably, in my view, by the European Commission. Otherwise, we have the chaos we had with the booking cases. Yeah? If you remember the online reservation sites, there were different decisions. In France, we had a law which prohibited any kind of most favored nation. In Sweden, we had another rule by the competition authority there. In Italy, another one. We had that was a patchwork of decisions where even the national competition authorities didn't come to terms to find a uniform solution to that legal question. And well, now we have this reference also to the Court of Justice, which will hopefully unify But again, here the question is, I mean, which is a bit in line with what I asked before. Does the standalone private enforcement before the civil courts not add confusion, disparity, and go into the detriment of the uniform application of the competition rules in an area where the law is still being defined? So I think it is a different question if you apply the competition rules to the, I don't know, to the cement sector or whatever, yeah. But in technology markets where there are so many things still to be sorted out and to be even to be confirmed on appeal in the 3 Google cases by the European courts, that I query whether it is the right moment to jump into the standalone pool of private enforcement in that respect. There are other cases also in other countries. I mean, we have in the UK, where's that? The Epic Games, which is also a parallel claim brought in the US, where the first judgment in first instance by a district court, I think it was in California, against Apple was already dismissed there. And where the Competition Appeals Tribunal is hearing a claim, a suit by Epic Games, which is the editor of, as you know, the youngers will know better than I do, of Fortnite. And so Fortnite was expelled from these 2 operators because Epic Games rejected the contractual obligation imposed on any third-party application on vis-a-vis Google and Apple to use their internal payment system, and this goes along with payment of a commission of 30%, and this is under investigation also both before the EU in the Spotify case and also in the US. We have the claims of the FTC and the Department of Justice, which I mentioned before. Again, this, in my view, is not private enforcement. They have to go to court. It's the American system. It's public enforcement. It's how they do it there. And it has taken them quite long. So I think they lag like 10 years behind the European Commission in realizing that there is an enforcement, I would say, necessity vis-a-vis large gatekeeper platforms. And so we have the case against Facebook, the aim of which is, I think, a very difficult one, because they want them to divest Instagram and WhatsApp, which is where transactions which in the US were authorized by the FCC. So difficult case. I wouldn't like to be the lawyer there. And in Google, you also have these exclusivities. I mean, if you open your iPhone, your preferred or automatic and pre-installed search engine is Google, and this goes along with huge annual payments from Google to Apple. And so all this is being looked at. I also mentioned here, but it's a bit besides the point, but Senator Elizabeth Warren, before the last presidential elections in the US, asked or said that big tech companies today have too much power over our economy, our society, and our democracy. And this is why in the US in particular, the spin-off of big tech is a political issue, which is under discussion. It used to be also under discussion for Microsoft for separating the operating system from all the other applications. And in the end, it was not necessary because technology evolves, and Microsoft is by large no longer as dominant as it was. But I mean, you see there that there are a lot of public policy issues which need to be addressed. Now it doesn't work here. Oh yeah, now it works again. Good. And so I've looked, since my part of the presentation is of this panel is Spain, I've looked into standalone. No, but this is one too far. How do I skip back? To roll back. Okay, now I have it. No, this is forward. This is forward. Standalone Article 1. There we are. Thank you. So I've looked into standalone actions in Spain. There aren't many. The first case is a famous one, the conduit case, where Telefonica, this was brought before the commercial court number 5 in Madrid, and they asked for a lot of damages, 9 million, which were significantly reduced. So they really went out with a tip with 630,000 euros, I think it was, because all lost profit was rejected, and also the damage as such was reduced. The conduct here, which lay at the heart of the damages claim, was that Telefonica supplied incomplete and deficient data to a directory services operator. And I think this was an easy case to apply Article 102 because there was a regulatory infringement. So there, for the judge, it's not so difficult to qualify that as an abusive conduct. And so this is the first standalone case to my knowledge. We then have the cases of several cable operators against Canal Plus in Spain, which is Audiovisual Sport, and its parent company, Cable, which was the holder of the broadcasting rights for the National League football competition and also for the Champions League. And in these contracts, there were agreements on minimum payments, irrespective of how many subscribers you have. And this was then also qualified, the refusal to renegotiate those guaranteed minimums in view of much lower subscriber figures was qualified as an abuse of a dominant position. I think the dominant position was quite easy here. I mean, they were the right holders of of all the rights in La Liga and also in the UEFA Champions League. And so damages were awarded here. Although I must say here, the test is a difficult one. I mean, the test, under competition law, to qualify a price as excessive under United Brands, it's a double test, and it's a complicated, sophisticated test where you really need economic expertise. And it's a case. Excessive prices are not classical competition law cases, and so although there might be a tendency to think, well, this is a very high price, this is by far not an excessive and abusive price under competition law, because competition law does not have the objective of regulating prices. It regulates the competitive process, and the outcome is irrelevant or open for competition law. Competition law doesn't say, no, the price must be 120 and not 150. This is, for a competition lawyer, this is a completely strange reasoning. So therefore, an excessive prices case before a commercial court, a civil court, is something, in my view, delicate. The other cases, and it was an abusive early termination of the contract, also damages awarded there. Then there were some electricity cases where on appeal then Iberdrola was where we are now. This is the tower we have in front of the university, was held not to be dominant. So that was rejected. Then we have the parallel trade cases. That was a claim for abuse of a dominant position filed by the European Association of Parallel Traders against one pharmaceutical company, Janssen, also before the commercial court. And when Janssen, together with all the other pharmaceutical companies, reduced the number of wholesalers and introduced unilaterally a supply quota system and a dual pricing system. And so this was also rejected on the grounds that there was no dominant position. And this also went on appeal, but that was also a standalone case. And perhaps the most interesting one is the one we are litigating right now, which is the Superliga, the Superliga, European Super League company against UEFA and FIFA, which is a case which is currently pending before the commercial court number 17 in Madrid. The judge a year ago adopted ex parte, in Spanish, inaudita parte, interim measures, which were lifted 1 year later due to the opposition filed by UEFA. And the judge also made a very early, but strange, preliminary reference to the Court of Justice, which I've quoted here, so you have the reference if you want to look it up. And the question here is whether UEFA's statutory rules, Articles 49 and 51, are contrary to Article 101 and 102. These rules confer on UEFA the exclusive right to organize international tournaments, international competitions, football competitions in Europe. And the Super League, as you know from the press, wants to launch its own alternative competition, but at the same time, they want to continue participating in the national leagues. And that's the problem. I mean, you can organize your Super League if you want, but if you want to break the whole pyramid model on which European football and worldwide football is built, then there's a problem with the European sports model and also with the open character of and sport based on sporting merit of football competitions in Europe. And so this is what is being discussed in this case, and it's perhaps the main case that has nothing to do with the digital market, or not so much, but it's a standalone case, and there are not so many. Standalone case. This is too fast for me. I'm too clumsy for that. A ver si pulsando el botoncito. Ahora. No. Okay. Now we have damages actions. In damages actions, you will see, and I'm certainly conducting you to my conclusion. Yeah. Inadvertently, you will realize that at the end of my presentation. But these are the cases we have. I haven't left out any. I'm not talking about Article 101 cartel damages cases. I've looked into cartel cases related to Article 102, and they are all follow-on. Yeah? We have 3C communications. That's a follow-on damages action for delayed interconnection. We have Tabacalera. This is a not public case, but I mean, I litigated it. That was settled for an abusive refusal to supply. The Telefonica margin squeeze decision from the European Commission from 2007. There were also 2 follow-on actions which were also settled. Then the famous one of the broadcasters against La Liga, which was dismissed. Was damages of 25 million were granted in first instance, but then on appeal it was dismissed for lack of causality because Antena 3 could not prove that the excessively long broadcasting agreements between La Liga and private broadcasters, which entered the Spanish market in 1989, which were 8 years long, really caused the damage. I mean, they said, well, perhaps your market share is even better, or your position without the football rights. Yeah? And they weren't so wrong in that. And we have some electricity cases, but the message here is, from what I've seen, and except for the cases we have looked into before, which were contractual, a bit of a contractual nature, all these cases are follow-on cases. Yeah? I have also picked up, just to that we have them in mind, the standalone cases on Article 101, which is the Moosa case, which is like a half standalone case, but I think it's a standalone case, which has to do with a collective boycott in the building insurance cartel, Seguro Regional, and this was a conduct which did not form part of the decision of the Spanish Competition Authority, and so therefore but the facts were recollected in the decision. Yeah? They were there, so they used the decision without the binding force of a declaration from the competition authority, but they used the facts which were collected in this decision in order to substantiate their claim, and this was approved, and I think they got about 3 million of damages, and they approved on appeal as well. And then in the Media Pro case, which went up to the Supreme Court, there was a horizontal non-compete obligation as regards between the shareholders of Audiovisual Sport, which was the company which exploited the football broadcasting rights. And so they agreed between themselves that only one of these parent companies would negotiate the renewal of the broadcasting rights with the football clubs. Yeah? And this was found finally by the Supreme Court to be a horizontal non-compete obligation, and then damages were granted for 30 something million. And then, and last but not least, the famous petrol station litigations, which are going on in Spain since, I think, 2 decades already. They don't end up finding the right focus, I think, but I myself, we also have one pending, which makes a different proposal. And there have been many preliminary references to the Court of Justice in respect of this litigation, but these are also more or less, I think, standalone cases. 5 minutes left. Okay, that's fine, because this is my last slide. So then, to conclude, what do these cases here, specifically in Spain, show us? I think the first thing to take away is that in the European private enforcement regime, which was adopted with the Damages Directive, which entered into force in 2016, and which is together readily applied already throughout Europe, although the transitional cases don't come into the directive still. But we lack in Europe the essential elements which you need for a private enforcement regime, which is substitutable of public enforcement. Because in the US, private enforcement has a deterrence and a punishment function. There are treble damages. There are contingency fees. There is discovery in the US. And also the usual cost rule is amended so that the loser pays the cost of the prevailing party. And all these elements, which we as such do not have, and even the 2013 recommendation from the Commission on Collective Actions recommends that there be no contingency fees, that there be no double damages or treble damages. And so they really recommend not to follow the American path, which the Commission tried in its first Green Paper in 2005. But after the criticism it received, they wrote back and then came out with a completely new proposal. And in this new proposal, private enforcement, private application of competition law in Europe mainly means compensation of damages, individual compensation of damages. The purpose and the objective of private enforcement in Europe is not, certainly not from the Commission's perspective, to be a substitute for public enforcement. And I think this is very important to bear in mind if parties bring novel, complex cases before the civil judges. In cartel cases, there are no complicated legal issues, but you don't have access to the evidence because cartels are secret. And the competition authority does have the necessary tools of inspection and discovery in forms of dawn raids, in forms of requests for information, and in form of the leniency policy, where parties come up themselves and voluntarily and come in with the evidence to the competition authority. In civil claims, you don't have that, and it's very difficult to uncover in a civil claim a cartel, unless you are part of it. But then what are you suing? In Article 102 cases, as I always say, and I think we should all petitioners in particular, be very aware of that, without leniency, there would be no damages cases, or at least only 10% of what we have. So don't kill leniency. Don't kill leniency with excessive damages claims. Damages leniency applications have already gone down very significantly with the Commission and with the Bundeskartellamt, who openly speak about that. The Spanish Competition Authority does not openly speak about that, but my personal and professional experience is that they have gone significantly down. And I have many clients who are not prepared to go in for leniency if they read every day in the newspaper what kind of damages and on what basis are awarded by the courts. And if leniency is that, damages claims will be over. Yeah? They will disappear. They will be a tiny minority of what we have today. So we have to maintain the right balance between public and private enforcement. In Article 2 cases, in Article 102 cases, I think the issues, as you have seen in the examples I've given, are complex. Market definition in novel markets, in technology sectors, digital markets, is there competition on the merits? I mean, is self-preferencing abusive? Do you want a civil judge in Barcelona? Do we want to decide this for, I don't know, with which scope? And with that thought, I finish. Thank you very much for your patience.
Thank you very much, Helmut. So let's see what happens in Portugal.
Okay. Can you hear me if I speak like this? Yes? I don't know. I hope people at home as well. I would like to start by thanking the organization for this wonderful invitation to be here today. Ben has been unable to join us so far, which means our moderator has informed me that I have longer to speak than I intended. I will thus take out my juggling balls to ensure that you are duly entertained. I would like to start in accordance with the Ascola Declaration of Ethics with a disclaimer. I am an academic, but I'm also a lawyer, and I work for the claimant side, including in digital markets action. So I want that to be absolutely clear from the start. I also apologize that I have no PowerPoint. I wasn't as organized as Helmut for this. And Helmut has given me many points that I wanted to reflect about. So I'm actually going to have to change a bit what I was going to say, hopefully in the interest of debate, and also to further the debate here in the room. So the first issue that I wanted to talk about is, why do antitrust standalone claims happen, and why do they make sense in a small jurisdiction such as Portugal? Because I'm going to be focusing on my reality. Okay, so first some statistics. Until 2016, according to an empirical study that was carried out, there were about 97 cases of private enforcement in Portugal in the span since the 80s. And of those cases, 93% were standalone claims. Okay, so this idea that most private enforcement was follow-on, that's only because people were focusing on damages actions, and they're forgetting that private enforcement is a lot of other things. But also, even in damages actions, that wasn't true. It wasn't true up to 2016. Then there were 4% that were follow-on and 3% were mixed. Now, after the damages directive, purely in numerical terms, if one looks at the number of actions, this has changed, because we're not like Spain. We don't have 100,000 actions or more in the drugs cartel, but we do have about 100 actions pending before the competition court, which is enough to completely, oh, all right. Move to here, I apologize. But we do have about 100 actions, which is enough to throw the statistics off. But if you consider the trucks cartel to be one case, still the situation today in Portugal is that the vast majority of cases are standalone or mixed. Right? I think that's important in terms of a statistical reality for us to start from. Now, it has also been made clear in Portugal that you can make a standalone claim in a situation where the competition authority has looked at the case and has closed it with commitments, or has decided not to identify an infringement. And that doesn't matter at all for the court. The court is just going to analyze what the claimant says, like in any other case. So we have a couple of standalone claims that are particularly important for the topic that we're discussing today. And I am acting for the claimant on both, so I can't say much about them, but they are the Google app and the Apple app case, which are also being run in the Netherlands and the UK and in the US. These are purely standalone claims. Although in the Google app there is a partial, it's a bit mixed because there is a partial overlap with a decision commission. Then we have mixed claims. And the reason for the mixed claims is that competition authorities are usually conservative when it comes to defining the temporal scope and the material scope of the infringement. Their goal is to build a strong case and apply fines. And at some point, they don't have that much of an incentive to try to increase the period or try to extend the decision to other practices, whereas the injured parties typically do have that incentive. So what we find is that in cases like, for example, Superboc and MasterCard, which are following on to decisions of the Competition Authority and of the European Commission, the claimant proposes a follow-on action, but then he also adds, hey, we think that this has been going on before, we think that this has been going on after, we think that this covered other types of things that weren't identified in the decision. So even though there's follow-on, you still end up having standalone issues. And why do we have these cases? Thinking specifically of Google app and Apple app, why did they happen? They happened because of discovery in the US. That's basically the reason. If we hadn't had discovery in the US and public court cases in the USA giving us these documents and giving us all this information, we would have no way to run such a case in Portugal. And that ties down to one of my main conclusions that I want to bring today, which is that the key to the success of a standalone claim, and this is true for digital markets, but it's true in general. The key to the success of a standalone claim, and Helmut has already addressed this as well, from my perspective, is two things. One, the scale of the cases. They have to be either cases brought by very large companies, where they're the injured party, or brought by a vehicle such as the CDC, which is represented here today, where you aggregate a lot of claims. So that there has to be a big monetary expectation of damages on the side of the claimant, so that they have the incentive to invest in building a standalone claim. The other way that this can work is in Portugal, for example, if you have, or the Netherlands or the UK, if you have a good opt-out system for consumers and also for undertakings, and you can go to court in an opt-out action using third-party funding. If these things are present, then you can do a standalone claim. You can be better funded and have better resources than the competition authority in such a situation, right? Better resources, but not better powers. And this is where the second point comes in, which is probably even more important, as Helmut already mentioned. It's access rules, access to evidence. And this really has become the crux of the matter. Also for follow-on actions, but especially in standalone claims. We know that the directive has tried to convince continental Europe that our access rules aren't working, we need them to be effective, we need to change them. But we also know that this is a cultural issue and it's going to take time. And certainly what we've seen in Portugal is a wide, we have an expression in Portuguese, I don't know if you, from 8 to 80. Completely different poles of interpretations of the same rules, right? In some cases, there are more rigid interpretations of access now than there were before the damages directive, because it's not about the law. And I really don't believe that any change to the law will ever solve this problem. It's not about the law, it's about the judges and their attitude and even their politics, not in a bad sense, but the way that they perceive their role in society and the way they perceive the role of justice, right? And so in some cases, with the exact same access rules, we get no access whatsoever, not even to non-confidential versions of public documents, right? Not even that. And in other cases, we get everything. Confidential documents, which we shouldn't be getting probably, because they're confidential. So we're all over the place. And a big challenge, if you're doing a standalone claim, of course, is that usually you don't know enough to go to court and meet the burden of allegation, right? Burden of proof, you can meet it later on, you can get evidence and you can solve the gaps. But you need to, especially in Portugal, I don't know in Spain, but in Portugal, they're very rigid about the burden of allegation. You need to make sure that you have the facts that you need to prove, the essential facts. But essential is quite a broad, is interpreted rather broadly by many courts. So in order to meet that burden of allegation, you need to know what happened before you file the claim. which means you either have a public investigation or you've done your own investigation. If we have discovery from the US, great. Well, then we have all the documents from the US. We know what happened. We might not have the evidence, but we know to ask for it. And we know to argue that this happened, right? And we can pull that off. And then it's up to the court whether or not they will give us the evidence that we need. The success is not guaranteed, but we can put the case together. If you don't have discovery from the US, what are you left with? Well, in Portugal, we're now testing these waters. We have 2 cases pending, which are started by a consumer association, News Omnibus. One, they're both following on to European Commission decisions. Meliá, a Spanish-based hotel chain, and Comcast Universal, which is a movie merchandising case. Not big decisions, they didn't attract a lot of attention, but they said, the commission said this affected all of Europe. But of course, there were settlements, and the decisions, typically when they're settled, they're negotiated and they say very little. We have no idea if the practice identified in the commission actually affected Portuguese consumers or not. It looks like it because it said it affects all of Europe, but there's very little data. So the Portuguese law allows us, it already did before the transposition of the damages directive, but I'm so happy I get 20 minutes. This is so different. This would have been a very different presentation. Oh yeah? Oh well, then I'm.
No, that's frustrating. That's frustrating.
It's too late now. It's too late now. So we're trying to use the pre-filing discovery mechanism, which technically already existed in the law in the Code of Civil Procedure, but nobody used it. And in our transposition, they put a special article reminding people, hey, you can use this for antitrust. And so we have these 2 cases pending. The competition court has already confirmed that you can use popular action, opt-out representative action in this way for pre-filing discovery. You can certainly use this mechanism, and it has confirmed the international jurisdiction under the Brussels regulation using Article 7.2, which is one of the big things that was being challenged by the other side. They're saying the defendant is in Spain. If you want to do pre-filing discovery, you should go to Spain. And the competition court said, no, Article 7.2, case law. This is still being appealed to the Lisbon Appeal Court, but I personally believe that the interpretation is correct. Of course, I'm representing the claimant, so my opinion is completely objective. If pre-filing discovery works, then we can, in principle, have standalone claims without public enforcement investigations, without discovery in the US. In theory, because the problem is, these pre-filing discovery claims are already turning out to be way too burdensome. Hundreds of pages are being written already, just to find out if we have a right to damages, if consumers have a right to damages. And they might not. So it's very hard to convince companies or a consumer association or a funder, that's impossible, to invest just to find out if there is a right to damages, right? So the other side is doing a very good job at disincentivizing the use of this, right? And of course, even if you get access to the documents and then you need to put a lot of man hours into reading all this paperwork to identify if you have a case, that's a big barrier to pass. I'm not saying it's unsurpassable, but it's certainly one of the things that we're going to be looking at in practice. How does this work? Is Ben around or? Yes? Okay, well then I'll finish very quickly with my final points. I'd like to say that there was another question, which is, are there specific challenges that are faced in claims relating to digital markets? We have several. I didn't include as many as, I didn't go as broad in your interpretation, Helmut, of what would be digital market cases, because we also have cases against a sports channel. We also have cases in the telecommunication sectors, standalone cases. We had Cogeco, which famously led to that ruling. But basically, the only ones that we have in the digital sector are against Apple for iPhone obsolescence, one of them, and for iPhone non-waterproofing, another case. And then we have the Google app and the Apple app cases. I think to some extent, there are specific challenges in these digital market cases, but those challenges are not that significant in the sense that you can have access to technical experts who can help you understand what's happening. It's not that complicated. It can be very scary at the beginning, but usually it's not that complicated. And I would like to do here, I'd like to reply maybe directly to something that Helmut said, which is, I don't think that there is any issue, economic law, well, certainly not law, but economic, technical issue. I don't think there is any such issue that would be too complicated for a national judge to decide. If the national judge wants to decide it, of course. And I think that the issue there is that it's a failure of the lawyers if they didn't do enough to make it simple and to explain it to the court, because any issue should be simple enough that you can, you know, I don't want to say dumb it down, but you can make it understandable. The other notes that I had is that this discussion shouldn't be done in the abstract. Each case is a case. Just because the case is in the digital sector doesn't mean it's complicated. Google app and Apple app are not really about digital. It's very little. The digital part is very easy to understand, and then it's really just old competition law discussions that we've been having for a long time. And finally, to say, on the matter of competition policy that Helmut raised, I don't think it is up to competition authorities to make competition policy. I would be more comfortable with courts telling us what the competition policy is, because in the hopes that ultimately that would go up to the European Court, and the European Court would tell us what the policy decision should be. I'm more comfortable with the judges telling us what the correct interpretation of the law would be than with the Commission, because sometimes authorities have political agendas. The European Commission is not an independent authority. It's not, even though it requires the national authorities to be, but it has no problem that itself is a political body. So I would prefer these policy matters to be decided by the courts, and I don't see that many policy challenges when it comes to digital markets so far, but possibly in the future there will be such issues. Thank you.
So Ben, good morning.
Hi, I'm so sorry. My apologies to everybody. I have completely messed up the timing, and currently in Portugal thinking it was the same time. So I'm very sorry.
We imagined. Don't worry. So it's your turn now. You have something around 10, 12 minutes, perhaps. Yeah, okay, 15 minutes, I think.
Don't worry, I'll be as brief as I can. So hello, everybody. Apologies again.
No, but we wanted to enjoy you, so 15 minutes, it's okay.
Okay. Apologies in advance if anything I say is repetitive of what's already gone before. That's obviously accidental on my part. So what I thought I would talk about is briefly about the noticeable shift that we have seen in the UK towards abusive dominance claims and some of the reasons why I think that development has occurred. And then secondly, a little bit as to why I think we will continue to see, at least in the UK, real creativity amongst claimant lawyers in this area, and particularly in the digital market space. So firstly, why has there been this trend towards abusive dominance claims in the UK? Well, it's long been the case, obviously, that with follow-on claims based on regulatory decisions, that there's been a race amongst claimant firms to be the first mover in terms of building or developing and issuing a claim. And over time, that pressure inevitably meant that firms increasingly started to consider the scope for jumping the gun and issuing claims before an infringement decision had been issued, albeit still on the basis that there would be a decision imminently. It's not surprising that the logical next step has been an increased appetite to issue standalone claims irrespective of the regulatory position. And Brexit has, I think, perhaps helped shape that thinking on this side of the water. It is no longer about waiting for the European Commission to act, and it's well known that the CMA's resources are clearly stretched. And so the further logical next step is for a standalone claim. It will typically be easier to bring cases that are regarding an abuse of a dominant position, than cases regarding horizontal agreements or cartels. Because if there is a sound basis to assume dominance with one entity, that is at least a strong starting point. Contrast this with a cartel scenario where there is the complexity of having to evidence secretive or collusive conduct. Now, yet a further logical next step is for the focus for these claims to shift to big tech, echoing the recognition at the regulatory level that broadly each of the big tech giants holds sufficient market power that they occupy a gatekeeper status in their respective markets. And there is the sense that dominance will at least be strongly arguable. And there is also the sense that regulators are perhaps moving too slowly in respect of big tech, and that they are limited in what they can meaningfully do, so that it is better to proceed with a standalone claim rather than wait. Now, we can see that this is playing out in the collective actions or class action space before the Competition Appeal Tribunal in the UK, the CAT. We have the Justin Lapaterol case against British Telecom, which is a standalone claim for abusive dominance. We have the Gutmann cases, both standalone and for abusive dominance in relation to rail fare tickets. The WICH, or the UK Consumers Association against Qualcomm, which is also a standalone abusive dominance claim. This is alleging that Qualcomm leveraged its dominant position in the supply of LTE chipsets to smartphone manufacturers into the licensing of its patents, so as to charge inflated royalties for the use of those patents. And the allegation is that these inflated royalties were then passed on to consumers. The claim's estimated value is around £480 million. We have the Dr. Rachel Kent case against Apple in relation to commission for in-app purchases, and the Elizabeth Cole case against Google. Again, abusive dominance and in relation to commissions charged on in-app purchases, albeit in the Play Store. And lastly, we have the standalone claim that has been brought against Meta, formerly Facebook, by Dr. Lovdal Gormson, which is, in my view, perhaps the most interesting one to watch going forward, as it is arguably at the very limits of the CAT's jurisdiction. And this brings me on to my second big picture point, which is that I think we are going to continue to see real creativity amongst claimant lawyers in the UK in this space. Now, taking a step back, it's important to remember that the UK collective actions regime only applies to competition claims. The competition sector is, if you like, the testing ground or guinea pig for how opt-out claims and aggregate damages will work in practice. And since the introduction of the collective actions regime in 2015, claimant lawyers have been trying pretty creatively to achieve similar effects in non-competition claims. And most notably, there was a spate of mass claims issued in respect of data breaches in the English courts. These were brought as representative actions under Civil Procedure Rule 19.6. And this allows for what are essentially opt-out claims, so long as everybody has the same interest in the claim. Now note, this same interest requirement is stricter than the more flexible commonality requirement in the CAT, which only requires same, similar, or related issues of fact or law. Now, not surprisingly, given the nature of big tech and digital markets, there are inherent concerns as to data and privacy. And this has essentially given rise to this spate of mass data claims that I mentioned. And the impetus was a claim brought by Richard Lloyd against Google on behalf of around 4 million iPhone users. The claim related to the collection and use of their browser-generated information, which was alleged to have been a breach of the Data Protection Act 1998. And the solution to the same interest requirement was to seek a lowest common denominator of damages across the whole class, so-called loss of control damages. You lose control of your personal data. And on the facts of the Lloyd case, this didn't actually work. And so the claim ultimately failed. And whilst there still remains scope for mass privacy and data claims to be brought under Rule 19.6, the Supreme Court judgment in Lloyd is widely regarded as having a restrictive effect in this area. And so it's in this particular context that the meta claim should be considered. It is framed as a competition law claim on the basis that Meta offered an unfairly low price, i.e. zero, for its users' personal data and only offered social networking services in return. Now, the reason I think it's interesting is that I think the CAT will be incredibly mindful that at its core, this is a claim arguably about big tech and personal data, and therefore arguably beyond a competition law jurisdiction. So it is definitely going to be one to watch. The CAT does not want to be the sort of backdoor into mass data and privacy claims, but given the nature of big tech and how digital markets work, we may see more of these. Now, given that the same interest commonality requirement under Rule 19.6 is so strict compared to the CAT's own collective actions regime, there are likely to be many more attempts at these mass non-competition law claims where creative claimant lawyers are going to try and, if you like, squeeze a claim within a competition law framework. And I have no doubt that we are going to see more attempts at this. And the underlying basis is that the notion of abuse under an abusive dominance concept is non-exhaustive. And therefore, the various grievances against big tech can arguably all be regarded as abusive conduct by dominant entities. Now, question how strong that argument really is and whether it can work in practice. But I do think it's interesting to see how this is going to develop. So that, from my side, is where I think the position sits currently in the UK.
And before 12:30, so great. So thank you very much. Are there any questions? I think that we have some questions here in the chat. Me gustaría plantear una pregunta a los ponentes. ¿Cuál es su opinión sobre las posibilidades del private enforcement en relación con las obligaciones y prohibiciones que establecerá la Digital Market Act? Well, at the end, it's the relationship between private enforcement and the DMA.
Well, we spoke about that in the previous panel, I think. No, it was my question. And apparently there's a role foreseen in this Article 39 of the DMA regulation for national courts. I don't see national courts declaring a platform to be a gatekeeper platform under Article 3. And I also have problems in seeing national courts imposing these obligations. I mean, but that might work. I mean, it's a regulation, and regulations are directly applicable. And so unless you introduce a mechanism, as the one I mentioned before, of Article 9 of Regulation 17, which gives the Commission the exclusive power to impose these obligations, which from a legislative point of view would be quite easy to accomplish, national courts could be addressed once you have a gatekeeper platform declared by the Commission, and then you ask a national court either for an injunction, as Gorka said before, to impose an obligation, or for interim measures in case an obligation is not being complied with. So, yeah, might be room for that. Yeah.
I would just add that I think, given the civil society environment that we've seen in the last years concerning these platforms, I don't know what will work, but I suspect that everything will be tried. That seems pretty clear.
I agree.
I couldn't hear the actual question, and I didn't understand the Spanish, but from the answers, I'm guessing it's the question marks surrounding the DMA and its enforcement.
That's
Is that
yeah.
right?
Yeah.
Whether there will be private enforcement surrounding the DMA.
Yeah, and I fully agree with what Helmut and Miguel said. I think it's as a claimant lawyer, I do have a little sympathy because I think the defendant lawyers who have raised concerns about how this is meant to sit alongside Article 102 generally and the risk of some sort of double jeopardy. I think that is a real debate. I can see that is a grey zone that needs to be worked through. I think it's also interesting that the view from the States is that the DMA is European regulation sort of, has it gone too far already? So it will be interesting to see how that works through, but I agree with what my colleagues have said already.
I mean, what is clear is that you won't have a tort until you do not comply with an imposed obligation. This is ex ante regulation. Yeah. And so just for being a gatekeeper platform, you are not in a tort situation. You haven't done any illegality. You're just big and fat. Yeah? So you need then non-compliance with an obligation which applies to you under Article 5 to give way to whatever injunction, damages, and so on. This is ex ante regulation. Yeah? So legal.
Any question?
Hello. So my name is Moritz Quecker. I'm a member of the Circle for European Damage Claims, and I would just like to contribute from my experience with a standalone lawsuit, because we were talking about access to information and also excessive pricing. And I happened to have filed such a lawsuit against the company Bosch on excessive pricing in a monopoly situation. There were also some other rules and competition rules in place, but we also based it on competition law. And what's interesting is that we didn't have any access to information directly, but the court applied a long-established rule of a secondary obligation or burden to demonstrate the pricing based on the internal cost calculation, which helped us to reduce the price by 40%. So it seemed to be possible to do this. And I wonder if there are similar rules in other jurisdictions, which has been interesting. Of course, access to justice in form of discovery or claims for information are important, but it was possible to do this without it so far.
The 40% reduction was in a settlement, I understand. It was a judgment. Oh, it frightens me.
We don't have any, I don't know any such rule that we would have in Portugal, but we do have examples of courts in Portugal identifying excessive pricing. So I think that in private enforcement, it's proven a lot easier for courts to decide that there has been excessive pricing, including in arbitrations, rather than in the public enforcement sphere.
Quick question. I'm going to say something that probably is not in agreement with Helmut, and this is always because he's so articulate, and he was a former boss also. I am not sure that I have a problem with judges taking different decisions, even wrong decisions. As competition lawyers or individuals who work with competition all the time, we want also institutions to compete. Why wouldn't we have a better outcome by letting judges compete in a sense, right? And also, is it different from other areas of the law where jurisprudence, case law takes time to develop, and probably at some point in the beginning, the court decisions are wrong? Why would I want to have this specific field of the law given to the commission, right, to monopolize interpretation? Why is this different? Are we perhaps looking short term? We should be looking by way of how the system should work, rather medium term, long term. a better outcome might be let the judges take even wrong decisions in the short term.
No, this is a question of how you think it's more efficient. Yeah, and I think in the new area, technology markets, digital markets, I think it's more prudent to have a public enforcement first to set the goalposts. Yeah, and that you then follow upon these precedents with a private application, standalone, if you like. And again, I do not think personally, but this is a very personal thinking, and you're certainly right to disagree. I mean, there's no objective or legal issue involved in that. I think private enforcement in Europe is meant to supplement public enforcement and not to substitute it as it does in the US. So it has no repressive or punishment mechanism or objective in it. It is for compensation of individual damages. This is, in my view, the philosophy of the damages directive. The court is going a bit further in his case law, Sumal, Skanska, and so on, and saying, well, private enforcement also serves the purpose of dissuasion and enforcing Articles 101 and 102. I don't agree very much with that, but if the Court of Justice says so, I have nothing to object, certainly, although I do. And yeah, it's a question of what you think is more efficient. I mean, as Miguel said, he feels better in the hands of judges who then eventually will come to higher jurisprudence and to preliminary references to the Court of Justice, and you will achieve uniformity by that. It will be a painful and long way until we reach that uniformity, and for dominant companies, also a very litigious field to operate in Europe then.
Till Schreiber, CDC. I have a question on the interchange and relation between public and private enforcement. Helmut, you mentioned don't kill leniency. Agreed, but I think this is a very important debate, and I'm sometimes surprised that it's the claimants, the victims of the infringements, which are now responsible for killing the leniency notice or the leniency program. In my view, the debate should be much wider. It's in particular as well for the competition authorities to take account that things have changed, that there is private enforcement, active private enforcement in Europe. And one debate I once had with Sir Peter Roth of the CAT, who has quite some ideas about how this could actually work to combine an effective private and public enforcement. One of the suggestions he had was that the immunity applicant, i.e. the first one going in, has an obligation to compensate and to provide the evidence so that victims can build their cases on that and pursue the damages against the remaining infringers on the basis of available information. Would that not be something that would be more effective, would reduce useless litigation for all parties, and be a more effective way? I think this is really a very important debate. I just wanted to mention this as an idea, which I share with Peter Roth. Thanks.
Yeah, I think certainly it's a good idea to give immunity also against damages to the immunity beneficiary. Yeah, that from the lege ferenda, I think, would be a good thing. Yeah.
It's 20, yeah, it's 20 to 1. One more question? One more question?
Okay. Thank you very much. Yes, do you listen? Do you hear me? Maybe Ben is the one who can tell us. Yes. He does not do anything.
Yes, I can hear.
Okay.
Oh, okay.
Sorry. Well, I'm Patricia Vidal from Maria Menendez. I act as claimant and as defendant, so I will try to be as objective as possible. I agree with what you said, Till, and I think that the Bundeskartellamt and Andreas Mund, in fact, and also if you listen to Maria Jaspers, I'm a competition lawyer, that's why I'm mentioning all these people. They are all trying to protect leniency, and in order to do that, they are also suggesting amendments, maybe to the directive, in order to give immunity to the from damages perspective to the first one who obtains immunity from a sanctioning perspective. I think it will work, definitely. So it's an open debate, because what you said, Helmut, is completely true. I'm publishing within a month probably a study comparing the trend in leniency applications in Europe and in Spain, and definitely we see they have just, well, disappeared, basically disappeared. And in Spain, after the Trax case, we'll look at 2018, the number of leniency applications are 0 or next to that, and always ex post an investigation takes place, very few of them. So definitely, if the potential leniency applicant believes that this is a lottery, that applicants to just file a claim, and regardless of the quality of your claim, you're going to obtain and compensation. Well, I tell you that in Spain, nobody is going to ask for leniency in borderline cases. Of course, if you have a market sharing agreement, I'm the first one saying go for leniency. If you have a doubtful practice with doubtful effects, I will think twice. Nowadays, I don't advise my clients to go for leniency because of the risk in Spain. I'm not saying in other jurisdictions. And my second comment, it was concerning DMA. I think that there is room of innovation, as Ben said. I think that unfair competition law might play a very interesting role for claimants, because if at the end of the day you have a regulatory infringement, at least in Spain, you can build it up. If you are big and fat, as Helmut said, you're big and fat, you can build it also as an antitrust infringement. So at the end, maybe we will have Spanish competition authorities applying the DMA, which is something that was never sought because the Commission wanted to monopolize it. So maybe we will have the authority applying it through the back door, and also judges. I think that, as Ben said, claimants will try to squeeze the concept of abuse in order to include things that are not abuse, privacy. But for some jurisdictions like Spain, for instance, in which we have unfair competition practices, maybe for privacy infringements, you don't need to squeeze the concept of 102 like a chewing gum. You have other tools. So I'm of course not proposing claims in this area, but I think that unfair law, unfair practices law opens many doors that we thought they were closed.
But sorry, I asked permission just to reply to something Patricia said, because you reminded me of something that in this debate about whether or not the beneficiary of immunity should get civil immunity as well. There's one thing that I don't hear a lot people talking about, which is what we're talking about is basically this company wants not to pay the fine and not to pay the damages. Maybe someone else would pay the damages. But there is an option which doesn't require a legislative change. It can be done now, and you can advise clients to do it now. Go to the competition authority, say, hey, we did this, we'll help you prove the infringement. And by the way, we're willing to arrive at some agreement with you where we're going to compensate injured people. And the decision itself can include no fine whatsoever, and a decision to say, and you guys are going to pay X amount. And here that nobody can hear us, you know, even if it's a small amount, it can drastically reduce the incentive to go to court to ask for the other amount, right? So there are paths that can be explored, I think.
Actually, if I could just quickly jump in, I know we're running out of time, but actually just on what Miguel said, interestingly enough, in the UK, where we have some of the pharma claims that have been brought, the damages actions, the private damages actions that have been brought on the back of the regulatory pay for delay decisions, have all been brought by our NHS, the National Health Service. And there was a recent decision by the CMA where the part of the decision and settlement was for the drug company in question to pay directly to the NHS a certain amount. In other words, as Miguel is suggesting, sort of bypassing, quite interestingly, the idea that there would be private litigation. I'm afraid the name escapes me of the particular long drug in question, but I remember a lot of people sitting up and taking notice of that as an interesting decision. So it follows on from what Miguel was saying. There is scope for that sort of flexibility.
That also happened in the, Patricia, what's the name of the case, which was a commitment decision from the Commission last year? Pharma. They also paid, as part of the commitment decision to the National Health Services of various countries, compensation, which was agreed in that decision. Yeah. Aspen, thank you.
I'm Joan Ramon Borrell. I'm professor in economics, so a little bit out of situation here, but I wanted to jump in this discussion about the incentives to participate, to apply in the leniency program and the cartel dynamics. We have been working a set of co-authors from the city of Malaga and Las Palmas, analyzing all the cartel decisions in the EU and Spain. So 1980 up to now and 1995 up to now. And the dynamics is a little bit tricky. Okay, so I wanted to raise some, we still don't know exactly whether really, as you are, maybe your point that the leniency applications are going down, maybe this is true, and this is caused by the compensation, the damage compensation affecting the incentives to go and apply for leniency, but we are not so sure. The dynamics is that what we see in the data and the papers we have published is that after the introduction of leniency, we see a sharp increase in the number of applications and decisions, right? But in principle, we expect the leniency applications to go down if they have the deterrence effect that we hope for. So it's not very clear whether this trend is a normal trend, and even this trend as a deterrence mechanism, if we have damage claims there, it should work even harder, right? So we are not very sure to what extent the number of cartels is reducing because of this concern, or whether nobody is applying, and then what remains are the very secretive type of cartels. But the incentives to go there, be careful, right? Because the firms can think, okay, if I'm not going up and apply, other firms can do. And maybe it can be worse, or nobody. Okay, so the question is that if this is so, it means that only the very secretive, very stable cartels, the cartels remain, right? And this drives me to the discussion that you were raising about to what extent the directive and the rules in Europe had only this compensation objective, but maybe by chance it is having some deterrence effect. Maybe it was not the purpose of the law, but at the very end, what we see, it's switching off, and what we see some deterrence going on, and although it was not the purpose there. So, and if this is interesting to see, I finished that, is to see that maybe it's not working so bad, and the actions are going to be there, although with less cartels. Times of crisis are times of breaking down of many cartels and creating the new ones. So maybe we'll have a new wave of cartels in the next future.
Yeah, but I'm sorry, we have to go on with the next panel. And we are 20 minutes on delay. Sorry.
Hello. Is that okay? 1 minute? Okay. I'm Joost Moman. I'm a litigation lawyer, not a competition lawyer. And even I, as a litigation lawyer, have noticed how much discussion there is about the immunity and how to balance public and private enforcement. What has surprised me is that in all these discussions, nobody raised the question whether it's even possible to grant immunity, full immunity, civil law immunity to the leniency applicants. Have anyone established that is compatible with Article 101? Is it compatible with fundamental rights? I think someone would need to establish that. Maybe the answer is very easy, very simple, yes, but maybe it's no, and then it kind of becomes redundant. Because it's, I mean, someone causes harm, sometimes on willful intent, and you deny the right to claim damages. Is that compatible with the right to property? I think that's a fundamental point that should be answered.
Okay, we have to finish here. Thank you very much. And let's go on with the following panel.